So good morning, good afternoon, and good evening, everyone. My name is Kun Fan. I'm the Associate Professor at UNSW Law and member of the UNSW Law's Herbert Smith Frisch Hill CIBEL Center. I'm very delighted to welcome you to the second session of the CIBEL Young Scholar Workshop 2020 today. I'd like to begin by acknowledging the traditional custodian of the land on which we meet today. I would also like to pay my respect to the elders, both past, present, and emerging. So as we know, in addition to the serious implications for people's health and public health care services, the COVID-19 pandemic also imposes significant challenges for the administration of justice. So in this session, we'll focus on the impact of COVID-19 on dispute resolution. We have 4 speakers covering a range of topics from international commercial courts to mediation of investor-state disputes, from renewable energy investment to public policy clauses in Chinese international investment agreements, which I'm sure will generate very interesting discussions. So each speaker will have about 8 minutes for comment. Each speaker will have about 10 minutes for presentation, and 2 of our commentators will comment for about 8 minutes, which will leave us about 30 minutes for Q&A. So I will encourage the audience to pose any questions you may have in the live event Q&A. And you can also put a like to the question that you want to be answered, so we will address them in the order of most liked. Without further ado, I will start by introducing our first speaker, Mr. Lance Ang of National University of Singapore. Lance is a research associate at the Center for Asian Legal Studies at the Faculty of Law, National University of Singapore, and an associate editor of the Asian Journal of Comparative Law. Lance graduated with an LLB from National University of Singapore in 2013, where she was placed on the Dean's list and also served as an assistant editor at the Asian Journal of International Law. So he will present to us today international commercial courts and the interplay between realism and institutionalism, a look at China and Singapore. Lance, the floor is yours.
Thank you, Kun Fan. Hello, everybody. So, international commercial courts have represent the next frontier in international economic law and relations, with the rapid diffusion of such courts over the last 2 decades, including in Dubai, Qatar, Abu Dhabi, Kazakhstan, Paris, and the Netherlands. So the Singapore International Commercial Court, the SICC, was established recently in 2015, followed by the China International Commercial Court, the CICC, in 2018 as part of China's ambitious Belt and Road Initiative. So my paper aims to examine how ICCs, International Commercial Courts, potentially reflect a broader emerging reconfiguration of transnational ordering in international dispute resolution and the support of a transnational rule of law within the frameworks of public and private international law, insofar as they serve or purport to serve to permit the autonomy of private commercial parties as opposed to state sovereignty to play a more significant role in determining the organization of adjudicatory jurisdictional authority amongst states. So my analysis proceeds along 3 questions. First, what is the potential role of ICCs in the framework of governance and dispute resolution in international economic law? Second, how is this potential role reflected in the institutional framework of the CICC and SICC? Third, what do these institutional characteristics of the CICC and SICC portend for the future of international dispute resolution? So the point of departure of an institutional account of ICCs within the framework of international economic law is its position as a nexus reflecting the conflicting interplay between realism, institutionalism, and liberalism in the forum state's transboundary economic relations. Just as a foreign state has an interest in maintaining a sound domestic dispute resolution mechanism for its domestic constituents to resolve intra-jurisdictional disputes, the state has an equal interest that other states also have similar mechanisms so that its citizens can engage in cross-border commercial transactions and ensure that their contractual rights in any judgments or arbitral awards attained in respect of such rights may be enforced adequately in the respective host state. So this is simply an extension of the standards of foreign investment protection under international law, the way I see it. This globalization of the marketplace has therefore generated a need for the global governance of transboundary private commercial dispute settlement between commercial parties to provide for a global public good, the transnational rule of law for economic exchange. The issue, therefore, is how can we manage relationships of economic interdependence between corporations and individuals across borders in international economic law when our preeminent legal institution still remains the territorial state. So ICCs refer broadly to courts which are intended to resolve international commercial disputes between private parties in which either one or both parties are international parties and the subject matter of the dispute is transnational and transactional in nature. They may be seen as effectively offshore or extraterritorial courts by giving parties the benefit of opting for the court's internationalized conflict of law and procedural rules and to opt out of the default regime which would otherwise apply under the domestic law of the foreign state. So in this sense, ICCs are institutions of transnational law, notwithstanding that they derive their constitutional and normative authority from the foreign state. They're extraterritorial insofar as they are generally conferred transnational jurisdiction that is not tied to any specific territory or personal connection with parties. They're international to the extent that they optimize their institutional composition and bespoke procedural innovations that are derived from the best practices in different jurisdictions and international arbitral proceedings. So in principle, the starting point under international law for a state's jurisdiction to adjudicate, like its jurisdiction to prescribe as an aspect of its sovereignty, is the requirement of an objective connection to the state. So this generally refers to factors based on territory and to a lesser extent the nationality of the parties as applied in different contexts. This may be juxtaposed with the extraterritorial jurisdiction that ICCs purport to exercise that often requires no connection whatsoever between the foreign state with the parties or the dispute. So this broadened jurisdictional ambit challenges us to rethink the concept of jurisdiction under international law. So one may argue that this reflects an underlying conceptual shift from two separate systems, international and domestic, to a common transnational system. So the key link that bridges the historical divide between public and private international law in respect of the role of ICCs is the broad acceptance by states of party autonomy of commercial parties in cross-border dispute resolutions, which some scholars have actually called a rule of customary international law in dispute resolution. So more specifically, it is the prominent role accorded to party autonomy as opposed to state sovereignty in the allocation of adjudicative authority as part of the global governance function served by the rules of jurisdiction in public and private international law. Party autonomy allows private parties the power to allocate adjudicative authority amongst states in their choice of submission to the state's jurisdiction and the applicable law and procedures governing their dispute, and away from states by submitting to a non-state forum, such as arbitration. So party autonomy, one may extrapolate, may constitute a new paradigm of jurisdiction, one built on transnational sovereignty of private parties. ICCs therefore may be said to contribute to the transnational rule of law, except that the substantive and procedural rules of law governing the adjudication are largely at the free disposition of the parties themselves. So arguably, however, depending on how ICCs are institutionally constituted and operate in practice, ICCs might not accord at all with such an optimistic account in practice. In this light, the proliferation of such fora raises untested questions about their institutional design, particularly in how they balance the twin competing objectives of state control and party autonomy. To this end, my comparison of the institutional framework between the SICC and CICC in my paper reveals a more complex picture than first appears. So the differences between both courts in brief summary are as follows. The SICC doesn't require connecting factors. It allows international judges. So the SICC doesn't require connecting factors. It allows international judges to sit on its panel. It allows foreign lawyers to represent parties. Its proceedings are largely customizable, meaning the parties can choose the way the procedural rules governing the dispute. Judgments can be appealed, but the enforceability of judgments across borders remains limited. The CICC in contrast, does require connecting factors. It doesn't allow international judges or foreign lawyers. Its proceedings are largely not customizable. It doesn't allow for appeal, but it allows for a retrial. And its enforcement of judgments, the enforceability of CICC judgments is similarly limited. So the comparison reveals that there is no uniform model of an ICC. In this respect, some scholars have proposed a grand Asian dispute resolution mechanism and a uniform centralized framework to resolve BRI disputes. This envisages an EU-style supranational court. One may question whether this is a utopian possibility in light of the current multilateral deadlock and the lack of international will in giving up state sovereignty, which militate against the potential for such a multilateral court. Instead, it is argued that the purpose of an ICC as an avenue for the advancement of the transnational rule of law is more limited. It is to mitigate friction, transaction costs, and commercial uncertainty in the application of conflict of law and procedural rules with other foreign states in respect of cross-border commercial litigation. So to wrap up, it is for this purpose that party autonomy remains an important objective on the basis that the ability of private contracting parties to choose the transnational rules of law applicable to their transaction and any potential dispute of such transactions enhances commercial predictability and certainty and reduces transaction costs. This is where I argue ICCs and the broader international community of domestic courts within the framework of international economic law are contemplated to play a useful role. Thank you very much.
Thank you very much, Lance, for the excellent presentation, which addresses a very interesting phenomenon of this commercial courts around the world. And I will certainly come back to you with some comments and questions later. So now I will introduce to our second speaker, Dr. Mark Loughlin. So Mark is the incoming Global Visiting Assistant Professor at Singapore Management University School of Law, and his research focuses on dispute resolution, Belt and Road Initiative, and international economic law. Mark has published articles on the Chinese approach of investor-state arbitration and also interaction between state-owned enterprises and mechanism for dispute resolution. So the topic of his presentation today is COVID-19 and the Singapore Convention. Has the stars aligned for investor-state mediation? Mark, the floor is yours.
Well, many thanks for that warm welcome, and welcome also everyone joining us from around the world. Now, the circumstances of the COVID-19 pandemic represent perhaps the greatest disruption to life and commerce in modern peacetime. Its global scale and extraordinary death toll have provoked unprecedented state intervention around the world. Many states have locked down entire populations and closed businesses. They have compelled the production of necessary medical items like masks and ventilators, and suspended bills for electricity, gas and water. Inevitably, foreign investors are amongst those businesses negatively affected by these measures. The legal background is the investment treaty regime. Since the first bilateral investment treaty was signed in 1959, states do not operate in a regulatory vacuum with respect to foreign investors. Over 3,000 international investment agreements ensure that, amongst other things, states must not discriminate based on nationality, must treat investors fairly and equitably, and must not expropriate without adequate compensation. Most importantly, if an investor considers that their rights under these treaties have been violated, they have the right to initiate an investor-state arbitration and seek compensation. In fact, over 1,000 of these investor-state arbitrations have taken place. The central question of my presentation today is to consider whether arbitration remains an appropriate forum for investors that seek to challenge measures related to the pandemic, or whether better options are available. Most notably, the recent conclusion of the Singapore Convention on Mediation, which makes international mediated settlement agreements enforceable, may change the landscape of investor-state dispute settlement. The methodology I've used for this is evidence from the 2020 International Dispute Resolution Survey conducted by the Singapore International Dispute Resolution Academy. And it suggests, in my view, that mediation is a good option for investors in terms of time, cost, and preserving the ongoing business relationship. The CIBEL survey focused on the experience of legal users and client users of cross-border dispute resolution mechanisms between 2016 and 2018. Users of investor-state dispute settlement were asked to select mechanisms of dispute resolution that they have been involved in, rank the factors that influence their choice of mechanism, and evaluate the usefulness of methods to improve the dispute resolution process. Now, the first step to analysing the appropriate dispute resolution mechanism is to characterise and give examples of state measures related to COVID-19. For example, El Salvador suspended bills for electricity, phone and internet. The United States compelled Ford and General Motors to produce ventilators and masks, and France has limited the activity of Amazon only to the delivery of goods. Other states, like Australia, Vietnam and South Africa, have adopted price or export controls to prevent businesses charging exorbitantly high prices for essential items, or to prevent the export of essential medical equipment. In Spain, hospitals have been nationalised by executive measures, and several municipal governments in China have authorised the requisition of property if deemed necessary to control the virus. All of these measures represent a significant interference with normal commercial operations, and there will be heavy financial costs to pay for the businesses involved. These may cause disputes between investors and host states. Against this background, there is a relatively significant chance of an increase of investor-state claims related to the pandemic. Now, arbitration dominates the world of investor-state dispute settlement. In the CIDRA survey, 82% of users had chosen institutional arbitration and 52% of users had chosen ad hoc arbitration, so arbitration dominates the field. When respondents were asked why, what were the most influential factors in the choice of dispute resolution process, they chose enforceability, impartiality, political sensitivity, and the transparency of the process. Based on these responses, enforceability was clearly the most important factor, and these mirror the institutional and infrastructure strengths of investor-state arbitration. The enforceability mechanism for arbitral awards is covered by the 1958 New York Convention and the ICSID Convention that ensures that arbitral awards can be enforced. However, there are several recent factors that may undermine this position. The recent Achmea judgment has called into question the enforceability of arbitral awards that involve intra-EU BITs. The recently concluded United States-Mexico-Canada agreement omits investor-state arbitration entirely between Canada and the United States, and the European Union's Multilateral Investment Court presents a challenge to investor-state arbitration. Furthermore, because of the financial and time constraints in states, there have been proposals for a moratorium on arbitral claims related to the pandemic. I'm not personally convinced by the substance of that, but I think it'd be interesting to see the level of state support for such a suggestion. Now, even if states were confident in their ability to defend these claims, the outcomes are very unpredictable. The leading example being in the Argentinian crisis in the early 2000s, tribunals decided in different directions, despite the fact that they were dealing with the same facts and the same law. Now, older bilateral investment treaties are also vaguely drafted, so it's very difficult to predict sometimes, not necessarily outcomes, but process. It's difficult to see how some of these disputes will be resolved. And in addition to this unpredictability, there is the issue of time and cost. Now, one study found that the average time for an ICSID award concluded was 3 years and 7 months, with costs up to $30 million, with an average of $8 million. As the pandemic will have depleted resources and governments and businesses will need to return to business, such a lengthy and costly process may not be the best option. Indeed, and I think this is a factor that's missed in the enforceability of investor-state arbitration, is that client users, 27% of client users, considered the flexibility of the process to be an important factor, compared to only 7% of legal users. This is inevitable because businesses would prefer a quick resolution of a dispute and to preserve the business relationship. And unfortunately, an arbitration prevents you from doing that in many cases because it's enforced by a third party. In the context of the pandemic, neither party can really be said to be at fault in most cases. It was the circumstances were external, and this may call for a more flexible approach. Now, in that context, one alternative is mediation, which is a relative minnow in the world of investor-state dispute settlement. In the Sudra survey, only 14% of responses indicated that they'd been involved in ad hoc mediation and 7% in institutional mediation. However, structural changes to the international legal framework for mediation and the particular circumstances of COVID-19 have created the conditions for the growth of investor-state mediation. As previously discussed, enforceability is the most influential factor cited by users of investor-state dispute settlement. Therefore, the recently concluded Singapore Convention on Mediation may be instructive. Upon ratification, the Singapore Convention grants new status to international mediated agreements and renders them enforceable as legal instruments. The central question with respect to investor-state disputes is whether they are commercial in nature, which is the scope of the enforceability of the Singapore Convention. Now, as a starting point, it does not define commercial, but it's also not included in the list of specifically excluded agreements such as consumer transactions, family agreements, inheritance or employment law. Indeed, the delegates rejected a proposal from the working group for commercial to be limited to commercial agreements between businesses only. Therefore, disputes have to be commercial in nature, but this is not limited to commercial entities. So in my view, this includes many instances, not all, but many instances of investor-state disputes. Now, the second most important factor was impartiality and transparency. Now, user confidence and impartiality can be supported by recent codes of conduct included in CETA, the agreement between Canada and the EU, and the International Mediation Institute has produced competency criteria for investor-state mediators, which include standards of confidentiality and experience of dispute resolution processes. Emphasising the professionalism of mediators will boost confidence in impartiality. Added to this, mediation has always been included in investment treaties and other soft law instruments, such as rules from the International Bar Association and ICSID, which clarify the rules for procedure. Aside from this legal framework are the issues of time and cost. As mediation requires fewer pleadings than arbitration, costs for parties tend to be lower. The institutional cost of mediation is less than 20% of the cost of arbitration at ICSID. The average length of an arbitration at ICSID was around 3 years for a decision at first instance and about 2 years for an annulment. In contrast, the vast majority of investment mediations were completed in under 2 years. So 70% of users involved in hybrid dispute resolution mechanisms cited the preservation of business relationship as a reason for choosing, for example, mediation or hybrid systems over arbitration straight. And I think that's what arbitration misses that mediation can offer. It's the preservation of business relationship and the flexibility of the process, particularly in the context of the pandemic, that can help states maintain their level of investment from existing investors and not ruin the existing relationship. Existing obstacles would be if, for example, states have purposefully privileged national businesses over foreign investors. In this situation, the parties lack the necessary prerequisite for a successful mediation, which is a genuine desire to settle. So, just to conclude, mediation is not a silver bullet for the management of investor-state disputes, nor would it be appropriate for all pandemic-related disputes. Indeed, the political sensitivity of some investor-state disputes may render mediation unviable, but in many cases, investors and states will benefit from the amicable and consensual resolution of disputes. With the correct organisational structure and the balance between transparency and privacy, mediation can have a considerable role to play in unsettling the assumptions underpinning the orthodoxy of investor-state dispute settlement in the post-pandemic era. Now that's me. Thank you very much.
Thank you, Mark, for the excellent presentation on a very timely topic. So we'll certainly come back to you with some questions later. And now I will turn to our next speaker, Ms. Hui Pang. Hui is a Santia PhD scholar at UNSW Law, and she currently focuses her research on renewable energy investor-state dispute settlement. Before joining UNSW, Hui was a Fox Fellow at Yale University for a year, and she graduated with a Master of Law degree from Fudan University in 2018. Her topic today is renewable energy investment and climate change mitigation. Is the investor-state dispute settlement mechanism ready for public interest litigation? Hui, over to you.
Thank you. I would like to thank CIBEL and its members for their continuous support and for this opportunity to present among such excellent panelists. I would also like to thank Professor Fan and Professor Trackman for offering their commentary and feedback. My research focus on renewable energy investor-state arbitration takes a narrow definition of renewable energy investments, which only focuses on direct foreign investment in the host state, mainly in solar PV and wind farms, where the investors are subsidized by the government for the electricity they provide to the grid. It does not include commercial arbitrations between private parties. The renewable energy investment disputes refer to arbitration initiated against the state for backtracking the subsidies previously promised to renewable energy investors. Back in early 2000s, the EU issued a climate and energy package and a renewable energy directive with a target for at least 20% of shares in renewables by 2020 to transit to clean energy consumption. Due to these policies, the investors saw an opportunity to invest in renewables. However, when the financial crisis hit in 2008, several EU member states decided to change the previous supportive regime due to a tariff deficit. Of course, it is arguable whether this change is merely due to the work of the financial crisis, but also maybe to the political views of the host state on climate change mitigation. For instance, when Spain overturned their supportive regime for renewables, the government was still providing around 4 million euros to subsidize fossil fuels. And now with a Liberal Party in government again, it plans to reinstate renewable energy investment support and ban fossil fuel subsidies completely. Of course, my research is not to investigate into the political intent of the state. Rather, it asks the question, can states' commitments under international environmental agreements, such as the Paris Agreement, form a basis for the legitimate expectation of renewable energy investors that the support regime would remain unchanged? Or is the regulatory change of the host state such a part of inherent state power that cannot and should not be challenged by investors' rights, even if the investors' rights are in alignment with the protection of a global public good, in this case, climate change mitigation? This question is important because even though it's important to promote and protect green investment, as well as private participation in climate change mitigation, it is also necessary to acknowledge the stakes of taking such an integrated approach. In other words, if we allow green investors to challenge the state's right to regulate, where are the boundaries to prevent the responsible investors from initiating arbitration against the state and the possible regulation chill that comes with it? Furthermore, is the current ISDS mechanism fit to balance between the protection of a global public interest that is in alignment with investors' rights with a domestic public purpose, such as to offset tariff deficit, or to allow the state to function properly under financial crisis? And that is a timely question because after COVID, we'll probably see many states taking this approach, saying that they have had such a tragic response to their economy, they have to stop either the ISDS system or they have to take emergency measures to stop investors initiating investor-state arbitration. And of course, as Mark has explained before, this also links us back to the Argentina economic crisis that has happened over a decade. And through examining the awards, I've also made a comparison in my paper between the previous economic crisis that has caused Argentina to take those emergency measures to Spain's proclaimed emergency measures and tariff deficit. Through examining awards that has been made available so far, I found that the tribunals have so far failed to acknowledge the complication of renewable energy investment, especially in terms of its connection to states' commitment of climate change mitigation. Some of this is due to the blurry and controversial interpretation of certain concepts and standards within investment law. In this paper, I mainly dealt with the inconsistent interpretation of what constitutes as specific commitment and what gives rise to legitimate expectation. For example, does the presentations and flyers given by the Spanish government explicitly explaining state support for renewable energy investment constitute as a specific commitment to entice investors? And apart from specific commitment, what else gives rise to legitimate expectations of the investors that the supportive regime would remain unchanged? Does domestic state policies in support of renewables and their international participation in environmental agreements count? Currently, most of the awards rendered have sided with the investor on this issue. deeming that a substantial repeal of the current supporter regime constitutes as a breach of the legitimate expectation of investors. However, if one scrutinizes the reasoning of the tribunal, one can find that arbitrators hardly ever address the principle of proportionality as a defense for the states in balancing the interests at stake, and such an omission could bring about negative externalities. Challenging the state's regulation to backtrack from supporting renewables might have defended a public interest. However, in many other circumstances where investors are allowed to challenge states' regulations, the result is often to hinder improvements in environmental protection or public health. Therefore, it's important to draw the boundary of state power and investors' rights, even when the investor's right is in alignment with the public interest. And that is the area where the tribunal seems not to have provided adequate reasoning. When dealing with the clashes of public interest, I argue that the tools of public international law for balancing between these interests should be taken into account by the tribunal, such as the principle of proportionality and the necessity defense. Another challenge for linking states' obligations to climate change mitigation under environment agreements with investors' legitimate expectation is the legitimacy and the scope of ad hoc tribunals. Some would argue that environmental concerns are beyond the jurisdiction of the tribunals. And considering the legitimate crisis that ISDS has faced in recent years, it's quite understandable as to why they take that position. However, environmental issues hardly ever exist alone without having some kind of relationship to environment, to economic advancement, such as investment or trade. Therefore, to exclude environmental related issues in investment treaty arbitration contributes to the fragmentation of international law and turns a blind eye to the tides of sustainable development in international investment law. In the next stage of my research, I wish to explore the legitimacy issue of the ISDS on environmental related disputes through the theoretical framework of the constitutionalism of international law, global administrative law, and public law nature of investment law. And that is a part that my current paper haven't had time to explore yet. And if you have any comments and feedback, I would really welcome them. That would be all from me. Thank you so much.
Thank you very much, Hui, for being very succinct also and making a very interesting topic. And also we will certainly have some questions to come back to you later. And now I will turn to our next speaker, Ms. Yue Zhao from University of Geneva. So Yue is a PhD candidate at the law school at University of Geneva, and she is conducting research on commercial and investment arbitration under the supervision of Professor Emerita Gabriel Kaufman-Kahler, and I'm very pleased that, in fact, she is also my supervisor when I was a PhD student a long time ago, and she is also under the co-supervision of Professor Jiaoyu Shi. Yue was a visiting researcher at the Danish National Research Foundation Center's Excellence for International Courts. Her topic today is revisiting Chinese IAAs during COVID-19 pandemic. Are public policy clauses a sufficient defense for emergency measures? So Yue, the floor is yours.
Thank you, Associate Professor Fan. During the extraordinary times of the COVID-19, states have implemented a host of public health and social strategies to slow the transmission of the disease. Well, these regulatory measures may give rise to investor-state claims, as many have noted, and host states may rely on the public interest clauses in international investment treaties to safeguard their right to regulate. Since 2008, public interest clauses have been widely inserted into the new generation Chinese investment agreements. But the question is, are these public interest clauses a sufficient defense for the regulatory measures taken during the pandemic? When we are talking about public interest clauses, we mainly refer to two categories of investment treaty provisions. The first is the general exceptions clause, which allows states to take measures otherwise inconsistent with their substantive obligations in order to preserve essential security, public health, public morals, and other public policy interests. The second category is the rules permitting states regulatory measures explicitly and implicitly provided in the clarified substantive obligation clauses. For example, this rule can be found in the expropriation annexes of the Korea-China FTA, which provides, except in rare circumstances, non-discriminatory regulatory actions for legitimate public welfare objectives do not constitute indirect expropriation. To the end of 2019, the Chinese investment agreement system is composed of 128 BITs and 13 FTAs containing investment chapters and subsidiary investment agreements. These two categories of public interest clauses exist only in 27 Chinese investment agreements. That is to say, 1 out of 5 Chinese investment treaties. And they don't cover the treaties with some major countries of a region of foreign direct investments, such as France and the UK. So as a partial conclusion here, it is fair to say that the public interest clauses are not common in Chinese investment treaties, or they are far from reshaping the landscape of the Chinese investment treaty system. Among these 27 treaties, 9 treaties include both kinds of public interest clauses, 8 only incorporate general exceptions clauses, and 10 only incorporate clarified substantive obligations. If a COVID-19 dispute arises out of the 105 Chinese investment treaties, which have no public interest clauses, the host state will have to defend its regulatory measures based on customary international law rules, mainly its defense of necessity and the police power doctrine. In the second part of my presentation, I will only focus on the 27 Chinese investment agreements that include a rather comprehensive set of public interest rules. But we will find that even based on these treaties, defending regulatory measures can be very problematic. Since time is highly limited, I will only discuss 2 questions. The first question is whether the general exceptions clause can exempt the host state from the duty of compensation. Here, let us read the chapeau of a typical general exceptions clause word by word. The Australia-China FTA says, nothing in this agreement shall be construed to prevent a party from adopting or enforcing measures for certain legitimate objectives. But what is the meaning of nothing shall prevent? There are 2 possible interpretations. First, as a rule tribunal, this clause does not stop the state from compensation. That is to say, the host state is not prevented from taking regulatory measures, but it has to pay damages. On the other hand, it is unreasonable to expect that states import the general exceptions with no intention of avoiding the obligation of paying compensation. So according to the principle of effectiveness, this clause, and as the Chinese treaties only include exception clauses, and for those treaties, it has to be exemption of the general exceptions clause. The second standard of review or degree of deference that arbitral tribunals should afford to national decisions in assessing the invocation of public interest clause. For example, if COVID-19 related to the Australian-China FTA I have mentioned, the standard of review issue concerns 2 important issues. First, whether the public health or essential security have been threatened by pandemic, and second, whether the emergency is sufficiently linked with the essential security or the public health. Mark and Hui have mentioned Argentine cases, and in this concerning the essential security exception clause in the US-Argentina BIT, we can find that arbitral tribunals are reluctant to elaborate on the standard of review issue, and there are no criteria identified in these cases that can be consistently applied in the degree of deference issue. So these two aspects illustrate that the outcomes of invoking public interest clauses are not very pretty. So even if we only focus on the 27 Chinese investment treaties that include public interest clauses, it is safe to say that the host state's regulatory autonomy is preserved. The problem is that due to the inconsistency of arbitral decisions, it is even difficult to predict the effects of those clauses. So we can see that the problem in the Chinese investment agreement system, and maybe in other countries' international investment agreement systems, the problem is not limited to absence of public interest clauses, which can be used to justify the regulatory measures during the pandemic period. The problem is that even in the presence of these clauses, it is still difficult for the host state to assess the legal consequences of its emergency measures in these extraordinary times. So we can say that the reform of Chinese investment agreements and the rise of the so-called new generation Chinese investment agreements are a plausible move. But we have to admit that this reform cannot fully solve the problems concerning states' right to regulate. Actually, the effect of the new generation Chinese investment treaties in preserving the regulatory autonomy of host states should not be exaggerated. The recalibration of the balance between investment protection on the one hand and the state's right to regulate on the other hand, particularly the state's right to regulate during the extraordinary times, should be envisaged not only from the perspective of reforming investment treaties, but also from a much broader perspective of ISDS reforms. But today, I do not have time to address the issue of ISDS reforms in detail. If you are interested in this topic, you can read my post-conference paper, and I welcome all the comments and questions in this regard in the Q&A stage. Thanks a lot, that's all.
Thank you so much, Yue, for the very interesting presentation on a also very timely topic. So I'm sure we'll come back to you as well in the Q&A session. So now I will turn to my colleague, Professor Leon Trackman, as our commentator. Professor Trackman is former Dean of Law at the UNSW and currently UNSW Professor of Law. He's also a member of our CIBEL Center. He's certainly a leading expert in the field of arbitration and investment. He's author and editor of 9 books, over 40 book chapters, and more than 100 articles published in leading international law journals. He's an international commercial arbitrator and also intergovernmental trade adjudicator appointed by the US, Canadian, and Mexican governments under the NAFTA. So we're very pleased that he agreed to be a commentator. And without further ado, I'll pass the floor to Professor Trackman. Leon, the floor is yours.
Yeah, welcome. I'm delighted to address the group, and there are 2 topics I'd like to emphasize because Kun will be dealing with 2 as well. And the person I'm going to perhaps start off with is Hugh Pang, and that's the renewable energy topic. So if you'll give me a little time, I did write a lot of things before, but I'm that much older, so I'm a little bit slower. As far as the renewable energy is concerned, Hugh Zhang, I thought both papers that I read I thought were excellent, that I concentrated on. And I think that the issues that are raised, I think, are particularly difficult to deal with, as was acknowledged in the presentation. The case for renewable energy is certainly one that is of paramount social importance, and it's a public and a investor interest. This is where there's a coincidence. Quality air, the idea of maintaining it, protecting it, etc. And we do have significant debate in countries like Spain around the scope of the state to disempower by virtue of its immediate interests. In other words, to regulate global public policy, which in effect means to regulate investors' rights. And the issue then becomes, should we be looking at renewable energy, and I think the paper deals with this in greater detail than the presentation, to address economic disasters, whatever they're defined, and we can debate extensively what is an economic disaster. It clearly has global ramifications, but it also differs in its ramifications impacting on particular countries, of which Australia has been very fortunate. So the issue is this a question of regulating an economic disaster? Is it an emergency measure? Is it one that is static? And perhaps the paper didn't deal with this as much, but we don't know. Or is it dynamic that in fact the emergency continues? The economic disaster is not instantaneous, but ongoing. And the difficulty for tribunals is they've been engaged in a rather traditional analysis. They've not seen investors effectively engaging on the good side, which is the global and the regional and the national protection. And I think that is a particular dilemma in order for states to recognize, rather in order for us to recognize the rights of states to exercise regulatory powers. And then the issue is where do they interfere, not just with the legitimate interests, fair and equitable expectations, etc. of the investor, but also have a massive impact in how they decide upon the global community, and insofar as countries are specifically impacted upon Spain. And that, I think, is a major adjustment and one that is not properly addressed. And I think the presentation does very well to look at reasonable expectations, fair and equitable treatment, proportionality. I think is very important. Is the state doing more than is proportionally justified to address its emergency? I think the issue of how does the public health, international versus domestic, how much of a relationship should that play? And the whole issue is around states protecting their localized interests, domestic interests, and then the broader international interest. How much should they play in the form of international customary law, or conceivably in some other broader dimension? I do also agree that the notion of ad hoc decision making does create problems because it ceases to provide a general jurisprudence to deal with the matter. And I think you've made a very, very good point there. So I like the presentation a lot. I think it's an advanced draft and I'd love to see it published and maybe to comment on it at some point if you'd like. The other presentation is the presentation by Hu Peng. Oh, sorry, I'm living confused. Sorry, it's this is also a very good paper, and I feel very fortunate having to comment on these two. The public interest beyond general exceptions. I find this another highly complex area, and as somebody who's specialized in the commercial state dimension, it is particularly complicated. I think arbitrators have difficulty with it. The first issue that I see is the general exceptions are very commonly used. They are effectively, as was mentioned, instruments by which states lost in many cases to investors from wealthy Western countries. So they were very broadly construed in favor of investor rights. And in effect, they were construed in such a way that national security, public health, environmental protection was effectively of limited response. The special interests issue raises its own particular problems. Kun, am I way over my time? No. Okay. The special interest issue raises some difficult issues. One can understand why it has limited role in China, largely because it's not very much reflected in China's treaties. It isn't really that much reflected globally, although it is being practiced for some time, and perhaps a qualification you will find an earlier ancestry to special interests than perhaps is suggested. In terms of third generation, it's perhaps a little bit more pervasive in terms of special interests. And it's really, in effect, an instrument by which states can, in effect, achieve objectives they couldn't otherwise achieve, at least supposedly, under the general exception principles. And I think your examples are very, very good. In other words, substantive obligations, modifying, limiting, constructing, constricting, narrowly interpreting, all of these can be vehicles that are used for specific actions on the part of states. In other words, this is a special case, and they hold up a special case sign, and that could be partly a very significant part of it. The issue, I think, as you mentioned very well, is the obvious areas around compensation. For example, does this modify the issues of compensation? Does it seriously impinge upon investor protections, contrary to treaties, or by way of modifying the investor protections in treaties? Is it effectively arbitrary? Is it unjustified? Contrarily, is it justified by necessity, the so-called notion of essentiality? And is it in fact, contrary to the protections, unfair and unreasonable, inequitable, contrary to the reasonable expectations, the legitimate expectations of the party? I think that this is the really difficult area from a practical point of view, because very often you will find that the broad construction of the general exceptions do encompass some of these situations. However, there is an attempt, I think, increasingly on the part of states to erode some of these protections by other means. And I think that becomes particularly problematic when you're looking at broadly based public interests. And as you've said yourself, in this particular area, we're looking specifically at the highly topical area of climate change. And let me just posit this as devil's advocate. I don't particularly like ISDS, and I've basically expressed views. I think it's entirely problematic. It has been adapted. There are lots of people that think it's wonderful. I have serious question marks. International investment courts and all the rest, I don't have very good alternatives, except to say that there are some inherent problems with it. You have to work with it, nevertheless. And the qualification I'd like to make is effectively, what does the result of all this, how does it impact on ISDS? Okay, I've got 1 minute. Oh, that's a very long finger. I like that thing. What's the impact on ISDS as a long-term practical issue? And I think one response is going to be that in this new world order with special interests, reduced investor protections, we are going to go into a time warp where we're going to say there are lots of options. We're going to have people pushing for investor courts. We're going to have people pushing for mediatory responses. All the things that I've said to date are going to be alternatives. They'll be back to the judicial solution. If states are going to exercise special interests, they're going to say, well, state courts should deal with it. We're going to look to an international facility like an Singapore International Mediation solution, which Mark, I must say, I wrote so who mentioned international mediation? Was it Mark? Yeah, I felt it's sort of rather problematic for me. The Europeans are dead against it, as you well know, many of them. We wrote an article in the Uniform Law Review, and they basically have 25 reasons. One is it's uncertain, it's a national prerogative rather than an international, and it doesn't lead to certain results. So, you know, is mediation an answer? Well, it may well be. But the bottom line is I don't know what the answer is, except to say that ISDS has difficulty when a foreign investor interest happens to coincide with a public interest, an investor interest. And I think that's the dilemma, and in fact for both papers. To what extent? Now, you'd say it doesn't really make a difference to ISDS because, after all, it could well be that the foreign investor, even a commercial foreign investor, there are public interests supporting them. But at the end of the day, I'm not sure it's a deficiency with ISDS in dealing with it. I think it's just a question that raises a whole lot of broader issues that we're coming to terms with now. And I think probably what's happened is the economic crisis, followed by the COVID-19, has essentially made us very self-conscious, probably very insecure about problem solving. And I think that's what I see reflected in the papers. And I think it's entirely justified. Thank you.
Thank you so much, Leon, for the very insightful comments, and I share with many of the observations that you have. So now I will focus my comments on the other very interesting two papers. I'll start with the paper of Lance that discuss on the international commercial courts. So I think this is a very timely topic. It addresses the interesting trend worldwide, the emergence of those international commercial courts created within the domestic system to resolve those cross-border commercial matters. And I think your presentation on this theoretical framework of international commercial courts is very interesting and very thought-provoking. Your paper itself also make a more in-depth comparison between the China International Commercial Courts and also the CICC in Singapore to illustrate how they reflect the interplay between realism and institutionalism in transnational commercial dispute settlement, which I thought was a very interesting perspective. So in the paper, you have highlighted a few important features of a CICC, such as the use of the Chinese judges and representation by the Chinese law qualified lawyers. So this certainly reflects a sort of departure from a fully internationalized commercial courts, which will require participation of reputable foreign judges and highly professional international lawyers, as we've seen in other commercial courts. Okay, so this limitation partly is due to the domestic legislations under, for instance, the Chinese judges law and civil procedure law, and partly is due to this mindset. I think that might reflect the attitude of this Chinese legal pragmatism, as described by Professor Yu Xingzhong, in the sense that only those transnational forums that do not break China's entrenched socio-political norms will be adopted, and that reflects also this Chinese selective adaptations. And in the paper, you described the establishment of CICC as a step towards increasing integration of the Chinese judicial system with the international political economy, which is consistent with the Chinese realism views in its sovereignty and foreign interference. I was wondering also that, on the other hand, as those international commercial courts, even though are established by the state, they also still have to compete within this international law market. And I think your presentation has also alluded to this. So this limited approach of CICC would not give itself the same sort of attractiveness compared to some other courts with benches comprising of leading international experts and flexible rules of representation by foreign lawyers, such as the CICC and also international arbitration. So it might be interesting to also consider the impact of those market forces and the bottom-up users' approach in the development of the international commercial courts and CICC in particular. Like Leon also mentioned, the user have the options. Right? So if it's appear to be less attractive, they could go to other courts and they could go to arbitration, they could go to a mediation. So again, it's, what impact would the user selection and the market force would impact the development of those commercial courts. And just to take CITEC again as an example, it was created within the state regime. Initially, there was a lot of administrative features of it, but eventually you have to compete in this market and you have to adapt. CITEC have amended its rules, have changed the practice over the year to bring its practice more in line with transnational standard, because again, I think it's driven by the market force. And I'm thinking about also Karl Popper's theory of the three wars. So according to this theory, I think the norms and practice in the commercial dispute resolution community can be considered to be in the sphere of Ward 3, which is the objective knowledge. So the world of products of humankind consists of abstract objects, And the objective knowledge has its own life, which can develop independently from world one of physical world, the objects, and world two of the subjective knowledge, so through our experiences. For instance, while the state, through its legislature and courts, create this knowledge system, but once the regulation rules and judgments are made, states then do not have the control over their future development. On the other hand, other state actors, like arbitration institutions, those international judges or experts appointed in those commercial courts, the lawyers and disputing parties also play an active role in shaping the norms and practice. And they may act in a way that demonstrate their own autonomy from the intention of the state. So in order to fully understand the function of those commercial courts, it may also be interesting to study from the perspective of the World Three's objective knowledge, which is beyond the control of the subjective world of the states. But otherwise, I think it's really an excellent paper and presentation that certainly deserve further discussions. Now turning to Mark's paper on the COVID-19 and investor-state mediation. A very timely topic, particularly in light of the unprecedented impact of COVID-19 on the global economy and the extent of the state's pandemic-related regulatory measures in response to public health concerns. So in this context, I think your argument on why mediation would offer a viable alternative to arbitration for pandemic-related dispute is quite convincing. And I wonder, you might even want to make a broader claim to advocate for mediation as an attractive alternative to arbitration for, indeed, many types of investor-state dispute, not just limited to pandemic-related ones. So as Leon also mentioned, that this dissatisfaction of investor-state arbitration is not a new phenomenon with COVID-19. So well before a pandemic, there has been some backlash against investor-state arbitration. It's becoming more confrontational, more lengthy and costly and judicialized. There's also, I think Pang mentioned the legitimacy crisis, right? Some calls it justice behind the door, and also questions the very accountability of investment arbitrator to decide upon those matters concerning public interest. And the final result may also be unsatisfying, even to a winning party. So as Abraham Lincoln once noted, how a nominal winner is often a real loser in fees, expenses, and waste of time. But I think in your paper, you address very convincingly of those advantages. And I believe the issue of the increased use of mediation for investor-state dispute is not a matter of whether, but rather how. And I'd be interested to hear more about the how. So one may wonder actually why parties are not using mediation more frequently, as suggested by the tribunal in the Ashmia and Slovakia case that you quoted in the paper. You discuss in the paper also some of the obstacles as reviewed in the survey, such as political sensitivity, and also you give some very helpful responses to the common objective. I thought it might be also interesting to refer to another survey conducted by the NUS Center of International Law, which investigated the obstacles to settlement of investor-state disputes. Some findings are consistent with the SIDRA survey, such as a desire to defer responsibility of decision-making to a third party. And I think the NUS survey also reviews some other obstacles, such as the media coverage, which can then pressure the state into taking a firmer stance, fear of public criticism, fear of allegation or future prosecution for corruption, fear of setting a precedent, and also the structure of the state, namely existence of multiple stakeholders in agencies and ministries across all levels of government. So I think some of those obstacles may also be worth addressing in your paper. And you've rightly noted in the conclusion that mediation may not be appropriate for all pandemic-related disputes. In some cases, it's just not a viable option. For instance, when the dispute involves an issue that is highly sensitive or politicalized or too far-reaching and could affect too many third parties. So again, in the NUS survey, some participants actually quoted the Philip Morris claim against Australia to illustrate this obstacle. But with the Singapore Convention's entry into force, actually next month on the 12th September, it will also be interesting to observe the effect of the Singapore Convention and the use of mediation to resolve the investor-state disputes. So overall, I want to congratulate all the authors for the very high quality paper and presentation that address very important and timely issues. I enjoyed reading them very much. And we still have quite a bit of time that we would open the floor then for the questions from the audience. This is a great chance because you don't have chance to grab the speakers. So I would encourage the audience to raise the questions in the chat box. And also you can put the likes in the order of your, like if you have questions that you wanted to be addressed, you can also put in the leg. So I might just start with a question, a general question. I think that at least related to both Hui and US paper, that you both sort of touch upon the limitation of the investment tribunal's power to sort of address issues that related to public interest, right? And that calls to the legitimacy challenge, as I mentioned as well. So I wonder what's your views as to the role of investment arbitrator? So as we think in commercial arbitration, arbitrator is often viewed as a service provider to the parties appointed them. And what about investment arbitrator? Are there roles? But again, they're also appointed by the parties, so there is a contractual relationship. But should they go further? Do they also act as a guardian of public interest, especially when reviewing the state laws and policies related to public interest, particularly in the COVID-19 context, right? As Mark has given some examples of those regulatory measures taken in reaction to COVID-19. So when arbitrator consider those matters, what should be the role of the arbitrators? Would Pang, do you want to address it first?
Sure. Thanks, Gwen. That's a lovely question. I actually think about that a lot when I write my chapters, because when we write a paper, we do want to kind of understand who we want to target. And when I write this paper, I kind of think, what is my target audience? Do I want to tell the arbitrators that they should take more public interest into consideration, or do I want to address the reform of ISDS? And I think that's a valid concern. How do we view investor arbitration that is different from commercial arbitration in terms of the arbitrator's role? My idealism, I have a very idealism idea about investor-state arbitration. I think it could be reformed to have that safeguardian role, to have those arbitrators to be like quasi-judges that actually do take public international law principles and public international law into consideration, not just to have commercial lawyers who act on behalf of either the state or on the investor. So that's why I am more for the investor court system that's been proposed by the EU. And I also do think that in that way, we could have more consistency in the awards, in the interpretation, or we might get to flesh out how controversial concepts have evolved in the past. So I do think that in the future, at least my preference for ISDS reform would be in that direction. But I understand a lot of arguments were against that because it is appointed by other side. You do have interest at stake, and at the end, it's an ad hoc tribunal. Where do we actually want to go back to domestic courts? Because maybe domestic courts is also a trend. And like South Africa, Brazil, and India has all backed out from the ISDS system. They've all said that now investors, they need to file within domestic courts first. And I think that's a major concern for developing countries because they want to safeguard their public interests. I might have said too much. I'll leave it to you. Thanks.
Thank you for your reply. And this is a challenging but excellent question. Actually, as mentioned by some scholars, especially Stephen Chales, there should be a conceptual reconsideration of the role of the arbitral tribunals. And this is related to the question here about the role or the function of the arbitral tribunals. Well, traditionally speaking, arbitral tribunals are trustees of the parties. But according to more and more cases concerning public interests, and we start to realize that to some extent, arbitral tribunal has the arbitral tribunal has a function similar to exercise of public authority. Well, I cannot give a certain answer here that whether the arbitral tribunal should be regarded as trustees of parties or a public authority. Actually, this is always a problem of degree, because the arbitral tribunal's role will fall in the spectrum, and two ends. One end is the private parties, and the other end is public authority. So it is always a problem of reconciling different interests in this process. But what has been omitted from the current proceedings is that the most arbitral tribunals have not realized that they have some kind of public authority role. And I regard this as a reason why public law concepts have been omitted in arbitral decisions. And this is one of the reasons why the arbitral decisions are not predictable, are not consistent, and sometimes not even correct. So yes, bringing the public law concept into the point of view of arbitral tribunals is very important. Thank you.
Thank you both. Yeah, this certainly is a very controversial issue that we can continue our discussions. And a follow-up question from the audience to Hui. You suggested that arbitrators should use proportionality to balance economic and environmental interests. So given the lack of institutional safeguard that presents at domestic law, do you think that the use of proportionality by arbitrator raises the problem of legitimacy?
Thank you. That's an excellent question. I think it goes back to what Professor Fan has said before, like the legitimacy and the role of arbitrators concerned. Can they actually safeguard public interest? But I do think that there's some interesting cases that has been developing in Latin America that we have not paid much attention to, where the international environmental agreement has a higher standard than the domestic law for environmental protection, and how that could be used as a sword rather than a shield for environmental protection in terms of in investor-state dispute settlement. For example, there's a case with Barbados, Allens versus Barbados, where he invoked the Wetland Convention and said that the state hasn't actually protected the wetland accordingly, and that's why he has suffered such a loss in his investment. Even though he initiated this arbitration with the particular intent to allow the states to perform better, to enact their environmental law better, but the investor-state arbitration court turned it down, saying that he can't make the causation between his loss and the government's omission in taking care of that wetland. So, but I do think there are things to tease out in those kind of scenarios, how we can actually make a very new liberal kind of idea of investor-state arbitration into something that does provide better protection for greater public good. And I do think that proportionality plays well into it, but it goes back to Quinn's question about how we position arbitrators. Do they actually have that conscience and morality within themselves to be able to safeguard the interest of public goods? Or are we expecting too much of them and it's just a contractual relation? Thank you.
Thank you, Hui. Now I have a question for Lance. So one of the questions you raised is that as a rational economic actor, what is a foreign state's interest in assuming jurisdiction for disputes to which it would otherwise have little connection? I think a related question could be raised is why would commercial parties then choose international commercial courts as opposed to arbitration? Right, so what are the advantages of those commercial courts as compared to international arbitration? Lance?
Yes, thank you for the question. I think I'll answer the second question first, which actually was already partially answered by the earlier commentators about the defaults of arbitration, whether it's sufficiently attuned to public policy or public goals. But essentially, the narrative that is put forward by the promoters, if you will, of international commercial courts, and most of these promoters are actually the domestic courts themselves. So, for example, the Singapore Chief Justice, in one of the earlier speeches that he gave, he actually did say that the problems with arbitration are essentially that it has led to rising costs, procedural delays, and unpredictability in decision making, which actually goes against the original purpose of arbitration, in the sense that parties would not have to rely on the procedural inefficiencies of the domestic dispute resolution system. Other issues would be like ethical concerns about the appointment of arbitrators, that the autonomy of parties to appoint arbitrators may actually lead to certain impartiality issues, and there's a lack of regulation of the practice of arbitrators. From a more public perspective as well, I mean, you may see that we may actually see the advent or development of the ICCs as an example of the reassertion of state sovereignty, if you will, of states coming in to compete with arbitration, and also to ensure greater public accountability and consistency in arbitration decisions, which are not published and which won't lead to a jurisprudence. So this is what the Chief Justice actually said was an obstacle toward realizing an international commercial law, a so-called lex mercatoria, given that arbitration decisions are usually confidential and they're not published, so there's a difficulty in ensuring consistency. Basically, with respect to the first question, yes, this is actually a trend, that, like I said, there's a trend of party autonomy that most courts would actually give effect to the party's choice of court agreement. This is a development that precedes international commercial courts. But what is foreign states' interest? I mean, in relation, in the context of international commercial courts, to put it simply, I think the comparison between the CICC and SICC actually sheds light on this issue. So like I said, the broad jurisdictional ambit of the SICC without the need for connecting factors is really basically to ensure that the Singapore courts can basically compete with other courts for dispute resolution business and extend their market share, which goes to your earlier point, Kun Fan, about the competition amongst courts. In contrast, the more limited jurisdictional ambit of the CICC, insofar as connecting factors are required, basically just shows that the CICC was set up for a different purpose altogether, which is basically to ensure that Chinese parties essentially, actually a prominent scholar by the name of Susan Finder, whom I interviewed for the purpose of my paper, who actually sits on one of the expert committees of the CICC, actually said it's basically a way for the state to move dispute resolution from outside China back to China, to basically, because previously, before the ICCs, most Chinese parties would have relied on commercial arbitration outside China, which may place Chinese parties at a disadvantage. And so we may see that the CICC is really meant to underwrite the transaction risks of Chinese entities and SOEs participating in the BRI, in the sense that it basically gives Chinese parties the advantage of the home advantage, if you will, of the reliance on Chinese procedures and Chinese rules. So that is the reason why connecting factors are required.
Thank you so much, Lance, for the great responses. And now we also have two questions to Mark. First question from the audience. Mark, I would like to hear your opinion on how the Argentina's case's narrow construe of necessity in economic crisis might have an impact on the interpretation of necessity criteria for the COVID-19 economic recession.
Okay, that's an interesting question. The issue I find with the Argentinian cases is that I believe it was a simple error in law. The conflation of the necessary nexus requirement in international investment agreements versus the customary international law definition of necessity, I believe was an error in law in conflating those two. And so despite lots of the huff and puff about the unpredictability of arbitration and how international investment agreements actually undermine predictiveness in the entire system, I believe it was just an error in law by those arbitrators, and it's been written about quite a lot. I think Professor Jürgen Kurtz has written about it a lot in particular. The second part of that is whether an economic crisis falls within the definition of an essential security interest. Now, there's a really interesting paper in the Journal of International Economic Law written by William Moon, who's given a very detailed analysis of the preparatory work of the convention and the conventions on which it is based. And he makes a very persuasive case that the essential security interest is basically limited to military activities. So on that basis, I'm not sure whether an economic crisis would fall within the definition of a narrow definition of essential security interest, given that it doesn't necessarily engage anything like arms, nuclear weapons, armies, and that kind of thing. Turning to specifically necessity, I think the circumstances of COVID-19 probably would fall within the definition of grave and imminent peril. The more difficult issue would be whether the measures taken by the states are the only way to address that, given that they've all addressed it in different ways. And the issue of that you cannot invoke necessity if you have contributed to the crisis. So if, and as I'm sure investors would argue, that some states have not taken the correct measures, they've locked down too late, they've locked down too early, for lots of reasons, investors will argue that. How successful they'll be will obviously kind of depend on the arbitrator and the particular state. But I think invocation of necessity is highly unpredictable in this situation because of those reasons, because it's not the only way, because you don't know how they'll assess state fault. Yeah.
Thank you, Mark. Now we have one final question also addressed to you that's related to the survey that you quoted. So in the survey, it shows that 80% of users involved in investor-state disputes use institutional arbitration, as compared to 52% use ad hoc arbitration, whereas in contrast, 14% made use of ad hoc mediation and only 7% use institutional mediation. I wonder if you have any thoughts. What are the reasons that institutional arbitration is more popular than ad hoc, while ad hoc mediation is more popular than institutional mediation? Mark.
I think the leading reason for that would probably be the inclusion of exit arbitration in many international investment treaties, whereas institutional mediation, as you concluded in your own paper, Professor Van, is very limited in most international investment agreements. In more recent ones, it is becoming more frequent, but even then, reference to mediation institutions is much less frequent. You know, whether that will change after the Singapore Convention on Mediation, once it becomes more integrated into the investor-state dispute resolution architecture or infrastructure, and if confidence starts to be gained by parties in the resolution of resolution of disputes through mediation, then it may switch, I think, to institutional mediation. I think for many, because after all, these mediation institutes or arbitration institutes are, after all, businesses. For lots of the time, they're trying to make money to some extent. And so before, there was very little clientele for investor-state mediation. Now, with the enforceability provisions, there may well be more. But I think it will depend a lot on the perception of investor-state mediation going forward. In my view, the two main problems that I referenced is, one is the inability of the state to be able to mediate, if it doesn't want to mediate, that it would be politically very difficult to conclude any kind of mediation, given the political forces that they'll face at home, the allegations of corruption afterwards. And then the distinction between, or the difficulties in balancing privacy and transparency. Even the IBA rules on investor-state mediation separate, for example, the communication during mediation, which must stay confidential, to, for example, the outcome of the mediation, which must be published. Now, that is a balance, but whether that will be enough to satisfy the critics, whether you say, well, we'll negotiate behind closed doors, but once we've negotiated and not telling you the reasons why we negotiated, then we'll make it public. I'm not sure whether that will be viable or not. But I think as the confidence in investor-state mediation grows, if it does grow, then I think it will become more institutionalized.
Thank you, Mark. So I think that comes, we are about time to really close. So I really wanted to thank for all of our speakers and commentators for the great contribution, for all the audience for attending the workshop. So the presentations were all excellent and the papers are also great. We really appreciate your contribution. My special thanks to all my CIBEL colleagues for putting this event together, and particularly to our Fion and Jane for their support. As you all the speakers must have been communicated with them for various aspects of workshop. Without their support, this would not have been possible. So really thank you, Fiang and Jane. And so thanks again, everyone, for your contribution. And please do stay with us for the next session of the Young Scholar Workshop. The next session will start on 2:30 on investment law and also 4:30 on Chinese international business law and trade law. And we'll also have a final session of the CIBEL Global Network Conference on COVID-19 and digitalization of dispute resolution on the 3rd of September. Registration is still open, so some of the topic we discussed today might also come back in some later sessions. So stay tuned. I hope to see some of you for some future events. And thank you again, everyone, for your contribution. Bye for now.